Okay friends, my name is Dekye. Today I will presentation about concept of private international law. So first of all, private international law comes into operation whenever the court is faced with a claim that contains a foreign element. It means it functions only when this element is present and its object are threefold. Have a three. You must remember these guys because to about this very important. What remain of these elements is to prescribe the condition under which the court is competent to entertain such a claim. That means the condition under which the court is competent to entertain. So I think you guys already know what I mean. Then the next is to determine for each class of case the particular municipal system of law by reference to which the right of the parties must be exercised. The last is to specify the circumstance in which a foreign judgment can be recognized as decisive of the question in dispute. The next is the definition of private international law. Now, many definition with such many professor, many professor or expert, they taught the definition of private international law. One of these, I very mean this PIL is the rules voluntarily chosen by a given state for the decision of case which have a foreign completion. This means by Betty Polaris law. So the next was talking about rationality of PIL or private international law. So there are variety of territorial system dealing with same phenomenon of life differently, like birth, death, marriage, divorce, bankruptcy, contract, wills, and so on, right? Now, the moment that a case is seen to be affected by a foreign element, remember this, the court must look beyond its own internal law. Now, then it is impracticable in the modern civilized world to disregard foreign rules of law by sheltering behind the principle of territorial sovereignty. It is accepts that it is not derogation of sovereignty to take account of foreign law, right? Example of private international situation. One of parties may be foreign by nationality or domicile. You guys know what I mean? What I mean is one of the party may be foreign by nationality or domicile. Next I will take another example. A trader may be declared bankrupt in England having numerous creditors abroad. So what? A trader at England declared bankrupt, but because the trader having numerous creditor abroad, so another foreign, right? Because it didn't say that a trader declared bankrupt in England and having numerous creditor at England, right? So it talk this PIL talk about what this have a two position about this, like the trader at England at bankrupt, declare bankrupt because what? Because having numerous creditors abroad. So at another place, we take another example. The action may concern property situated abroad or disposition made abroad of property situated in England. Okay. I think another example is a contract may have been made in one country to be performed in another. It's good. This means this contract, a work contract, maybe office contract or may have been made in one country to be performed in another. So we make a one we can talk about a passport. This a book of passport we can use for what? we can use for go to another place, like, right? So we can go to Australia, we can go to the Singapore, we can go to Malaysia and another place, right? Now we can learn about the scope of PIL, Private International Law. Now, Private International Law is not a separate branch of law in the same sense as the law of contract or of tort. For example, it is all pervading. What I write is this: it starts up unexpectedly in any court and in the midst of any process. It may be sprung like a mine in a plain common law action. Now, in an administrative proceeding, in equity, or in a divorce case, or bankruptcy case, in a shipping case, or a matter of criminal procedure, the most trivial action of debt, the most complex case of equitable claims, may be suddenly interrupted by the appearance of a not to be united only by private international law. So you understand what I told about this? Now, about what I told you this, like PIL, Private International Law, is a separate and distinct unit in the English legal system, just as much as the law of tort or of a contract, but possesses the unity not because it deals with a particular topic, but because it is always concerned with one or more of three questions, namely jurisdiction on and choice of law and recognition of foreign judgment. And then the name of the subject. The expression Private International Law, or PIL, was coined by the story in 1834 in his book Commentaries in the Conflict of Law. Then it was adopted by early English writers such as Westlake and Foote, and its use is more civil law control. Now, the main criticism against this name is its tendency to confuse with public international law, between which there are obvious difference. About the characteristic of PIL, Private International Law. Now, Private International Law is a branch of municipal law. Private international law is essentially a system of indicating choice of jurisdiction, choice of law, and recognition of a foreign judgment. Now, private international law doesn't give a final final decision. It is comparable with a railway inquiry room. By approaching the inquiry room, you can only access the platform from which a particular train leaves. Like this. The basis of PIL, like we talk about justice. Grafson said the basis of PIL is sociologically in the international nature of human affairs, ethically in the desire of English court to do justice, and legally in the obligation of their oath in office. The three principal questions of PIL. Choice of jurisdiction. Has the court jurisdiction to deal with a specific issue? I think how about you guys? Has the court jurisdiction to deal with a specific issue? Nah, the court decide the jurisdiction first. It is decided on the basis of the claim of the petitioner or claim of the plaintiff. Either explicit or implicit, the jurisdiction has to be decided. About the choice of law, by what system of law should be specified issue be decided? About the choice of law, the first and the second question may be determined by one law, and the third question may be determined by the law of the place where the marriage was celebrated. Like what? Like, had the parties capacity to marry? Was there any prohibition for solemnizing their marriage? Right? The first and the second question may be determined by one law. Now, about this, was the marriage celebrated according to the prescribed formality? This third question may be determined by the law of the place where the marriage was celebrated, right? Now, the choice of a law. Example, I take a case. If a suit is filed for a damage for breach of a contract entered into between a Burmese resident trader and a Chinese resident trader in Dhaka for a supply of certain quantity of rice to be shipped to Calcutta, now presume that the suit has filed in a Calcutta court. The question before the Calcutta court then, which law is to be applied? Law of Burma, law of China, law of Bangladesh, or law of India? About this, we must learn about recognition of foreign law. There may be situations to take into account foreign law on a point for decision. The reasons are twofold. First, the invariable application of local law may lead to the injustice. Suppose that a person engaged in English litigation is required to prove that she the lawful widow of a man who has just died, the marriage ceremony having taken place many years ago, the marriage ceremony thus regular according to the law of the place where it was performed. Perhaps this not satisfies the requirement of English law, but nevertheless to apply English law to such a union and thereby to deny a validity of the marriage would be nothing but a travesty of justice, right? So, and secondly, to consider only the law of particular country might well be to reverse the legal obligation of the party as which by the law to which their transaction both in fact and in intention was originally subject. This is what I mean at recognition of foreign law. So for the third is for intents or promise by a man by Englishman in Italy and to be performed there, if valid and enforceable by Italian law, would not be happy void by an English court merely because it was unsupported by consideration, right? Now, at least we must talk about private international law, right? So about this, we must take something like go to the private international law. So we must take a simple case, okay? Consider you guys must listen to me about this case. Then we can deal this case together, okay? What I talk, consider the following situation and explain the reference. Now, an Englishman and his wife are British citizens, domiciled and resident in England. When through a ceremony of marriage in England, later the wife petitioned an English court for a divorce. The spouse are still domiciled and resident in English. Now, a British couple married in France, domiciled and resident in England. At the time of marriage, later on the husband petitioned for divorce. At the time of his divorce petition, his wife is domiciled and resident in France. So, what I mean of these two cases? These two cases told us about domicile. Domicile is the country which a person officially has as their permanent home or has substantial connection with. Now, about resident is a person is considered a resident if present in a country for 183 days or more per tax year. International law versus national law. Think about the difference between national law and international law concerning. Now, we have three to concerning this the territory on which it is applied, and the two is the party involved, and the three is the source. How would you survive the international law according to the characteristic? Now, just now we talked about the characteristic, so I will talk about the international law consists of rule or principle which govern the relation and dealing of nation and other international entities with each other. About public international law, relation between several nations or nation and the citizen or subject of other nation. Now, about private international law, conflict between private person, natural or activity arising out of situation having relationship to more than one nation. So about just now public international law, the source is customary law and conventional agreement, treaties, convention, charter, judicial decision, judicial writing. But about the private international law, the source is a branch of internal law, national and customary law. Do you understand about this? I told you, an English and a French litigant have disputed over a breach of contract concluded in Italy to be performed in Spain. In your view, which legal problem would arise in such a situation? Which legal issue would have to be solved? Does this matter belong in the realm of public, private, or supranational law? Nah. Private international law. We back to this, a foreign element just now I talked. A part of national law which establishes rules of dealing with cases involving a foreign element. It is concerned with cases in which the parties of other relevant issues are connected with more than one country, just like I said. What do you think can constitute a foreign element? Nah. The term country in private international law. Country. Any territorial unit having its own separate system of law, no matter whether it constitutes an independent state politically. Decide which of the following territorial unit can be referred to as country in private international law, like UK, Ontario, California, Croatia, Scotland, Wales, Australia, Canada, England, Ireland, and Northern Ireland. Issue to be decided in the conflict law case. What issue do you think should be decided by conflict of law rules? Conflict of law. Have a 3. Jurisdiction, choice of law, recognition and enforcement of foreign judgment. We talk about the jurisdiction. In which legal jurisdiction may a case be heard. Determine whether the proposed forum has jurisdiction to adjudicate and whether it is appropriate venue for dealing with the dispute. Choice of law. The law of which jurisdiction should be applied to the issue in the case. Determine which of the competing states or law are to be applied to resolve the dispute. Right? Areas of law involving conflict of law. First, law of obligation. 2. Property and succession. 3. And family law. Now, we back to the choice of law rule. Court faced with a choice of law issue have a two-stage process. The court will apply the law of the forum lex fori to all procedural matters. The second one is it counts the factors that connect are linked to the legal issue to the law or potentially relevant stage in place the law that have the greatest connection. Example, the law of nationality lex patriae or domicile lex domicile will define legal status and capacity. In law of state in which property in situs or remain lex situs will be applied to determine all questions of title. The law of the place where a transaction physically takes the place or of the occurrence that gave rise to the legislation or remain lex loci actus will often be controlling law selected when the matter is substantiated. In any case, proper law will be applied. Proper law is what? Proper law is the law which seems to have a closest and most real connection to the fact of the case and so has the best claim to appeal. So I will make some example just now. I think divorce. Okay. The law governing divorce is the law of the states which both spouse they may choose one of the following law. The first, the law of the state in which both spouses had the habitual residence at the time of choice law. And the second one is the law of the state in which the spouse had their joint habitual residence if one of them is still not in this stage and has habitual residence. Case study 1. Who has a French nationality and residence in Germany? The answer is correspond with B. Over the internet, they agreed to join purchase a land of Switzerland currently owned by C, but they never physically meet. Case study 1, I want to tell you. A. Who has a French nationality and residence in Germany? B. who has American nationality domicile in Arizona and residence in Australia? C. A Swiss national owned property in Switzerland. The answer is what? We must explain the three option it is. About A correspond with B over the internet. Then they agree the joint purchase of land in Switzerland currently owned by C, but they never physically meet. And the B, they execute initial contract document by using fax machine followed by a postal exchange of hard copies. And C, A pays his share of the deposit, but before the transaction is complete, B admits that although he has a capacity to buy a land under his lex domicile, and the law of his residence, he is too young to own land under Swiss law. There's a vocabulary practice. Find these texts, the following English term and expression, and translate them into Croatian. Conflict of law rules, to law of the domicile or habitual residence, to raise a conflict of law issue. Part 2. About this following case, I will tell another case. Croatian couple married in France, domiciled and resident in Croatia. At the time of marriage, later on the husband petitioned for divorce. At the time of his divorce petition, his wife is domiciled and resident in France. How a characterize the cause of action into a legal component. What I want to talk about this characterization is the couple is from Croatian, because already told the domicile Croatian couple. Now domicile and resident and that means the lex is at Croatian. Now and the divorce, they have something like a asset or the thing he must give for her wife is the resident in France. Okay. So about what I can tell you about the concept of private international law. It didn't mean what I say is a loss, because in private international law so big, so wide. You can find another article, you can find another study case, you can find another study material. But about me, I'm here to tell you about the meaning of the private international law, the concept of private international law, and the mean and the some experience case. Then we solve together and we learn together, we analysis together like this. Okay. About this video, about this material, about this teaching, about the lectures, I want to say sorry if I got it wrong at the talking or speaking. I don't mean to harm you guys. I don't mean to be protest about this my language, because I'm half past Indonesian and half past in Singapore. So I must talk like a Singapore English, right? Nah, so I will say thank you about this. See you in another semester, guys. Thank you.